Supreme Court of the State of Colorado, now in session. Chief Justice Coates.
Please be seated. Good morning, everyone. We've scheduled a one-hour argument this morning in the case of Friend v. People. Both counsel have argued before, so you know how to work this equipment. Let me remind you, when you get up to the podium, we record these things, so if you could announce yourself and indicate what party you're representing, and then do your best to talk somewhere near the microphone so we can get your recording. And otherwise, if both counsel are ready, petitioner.
Good morning. May it please the court. I'm John Gervelius, bar registration number 41168, and I represent Mark Friend. Today, Your Honors, I'm asking this court to conclude that my client should remain convicted of no more than count 1, which is the child abuse murder count. This conclusion is required by principles of statutory interpretation and principles of double jeopardy and merger. Now, the Court of Appeals correctly held that all of my client's child abuse counts, that's counts 2 through 6, had to merge, but it incorrectly held that the child abuse counts did not merge with the child abuse murder count. And so this morning, I'd like to actually start with the first issue, the merger of the child abuse counts, and then transition to the second. The Court of Appeals correctly held that the child abuse statute under subsection 1A defines one offense in the alternative, such that it can be committed in alternative ways. This court endorsed that reading of the statute in Weinreich, and I take the state to agree with me on that reading up to that point. The Court of Appeals also correctly held, Your Honors, that there was only an allegation and evidence of one pattern or one course of abuse in this case, not several. The prosecution alleged and presented evidence of one pattern resulting in MB's injuries, and the prosecution alleged only that my client committed child abuse in distinct ways, but not in multiple times. During sentencing, the prosecution conceded that counts 1, 2, 3, and 6 were based on the same pattern of conduct, and that counts 4 and 5, the evidence supporting counts 4 and 5, comprised that pattern. Now, under this court's decisions in Molina, Quintana, Wolhoff, and Abiodun, we can resolve the issue of the merger of the child abuse counts on that basis alone, because there was no allegation of multiple volitional departures under that statute. This was one course of abuse under the statute, and that is it.
Well, Mr. Gervelius, let me ask you, what do we do with the fact that on one day we have an incident where the defendant is alleged to have thrown the girl against the door and hit her head, and on a different day alleged to have thrown her on the bed and she hit so hard she fell off and hit her head? That sounds like two different incidents on two different occasions.
That is correct, Your Honor. That would correspond to counts 4 and 5. However, the incidents that you refer to were both used as a pattern count. Actually, that's multiple counts were used that theory. That's counts 1, 2, 3, and 6. Used all of the allegations in aggregate to prove the ultimate harm to MB.
So is your position, so we have two separate incidents that are both alleged in the pattern counts, and then the pattern counts are alleged into the child abuse resulting in death count? Is that kind of the thought process?
I'm not sure I followed.
So we have two different incidents on those 2 days I just described. They also both form the basis for pattern counts. And so I think you're suggesting they merge to the pattern counts. Then the child abuse resulting in death is the accumulation of injuries from the patterns. So one merges into the other, merges into the other?
Well, it's that the child abuse resulting in death is a pattern theory by itself. And that, yes, the discrete acts that occurred on the 13th and the 15th comprise that pattern, that course of abuse. And the prosecution's evidence was such that the only thing that they could produce or prove was that MB died as a result of injuries occurring throughout that time period, which was those two discrete acts.
Counsel, if the prosecution had charged your client with committing a particular act on January 13th, count 1, and then count 2, committing a particular act on January 15th. Would that be permissible to treat it as 2 separate incidents? Is what you're arguing it is that it has to do with how they charged it?
Well, it would depend, Your Honor. It would depend on what the evidence actually showed. So I'm not saying that prosecutors can't charge discrete acts on consecutive days. What I'm saying is that the prosecution relies on all of those acts, including those 2, to support an accumulation of injuries theory, then it can't also use those discrete acts and actually have convictions. I mean, it can charge them, and it's entitled to try that to a jury, but however, my client or any defendant can't be convicted of both a pattern of conduct and the discrete acts forming that pattern under the child abuse statute.
And you mean ever, right?
Excuse me, Your Honor?
Ever, right? So it means anytime there is a pattern count that subsumes the predicate acts, if you will, or the individual counts that are within that same pattern, then it merges.
That would be correct, Your Honor. That's the way the child abuse statute is designed, is it's designed to allow the prosecution to look at the ultimate injury to the child, the ultimate harm. And if that's one discrete act, then it's one discrete act. However, if it's a pattern of acts, then the statute is such that it allows the prosecution to aggregate the harm, to seek a higher conviction. That's exactly how it works. But it doesn't allow the prosecution to then also seek conviction. Well, it allows them to seek conviction, but it doesn't allow the defendant to also be convicted of every single discrete act within that pattern. That is my position.
Let me go back to Justice Gabriel's question, follow up on that. So on count 6, the pattern for serious bodily injury count, the people argue that the evidence that supports that conviction is not the evidence that supports the convictions on counts 4 and 5. What's your response to that argument? I think their specific argument is that on count 6, the evidence they're relying on, or that they relied on, had to do with another incident on January 13, which followed the door incident in which the child became unconscious, and then the lack of, or the failure to seek medical assistance.
Your Honor, I didn't read the record that way. I had read the prosecution to allege that it was the same pattern. The only difference being is that it ended on the 15th rather than the 16th, because there was no, I mean, that was, the 16th is when MB ultimately succumbed to her injuries in the hospital, but I didn't read the record to show that there's any distinction in that pattern.
Well, that's one of the arguments they made in their brief, is that that pattern deals with something different than counts 4 and 5. Let's assume they made that argument. What's your response to the argument?
I don't believe that the evidence showed any distinct pattern corresponding to count 6 than to any other, the other evidence. It's also not only how they treat it, but whether the evidence supports the conviction as alleged, and there was no other pattern proven.
Do we look at both how they charged it and how they presented it at trial, one or the other? I was a little bit unclear on what your position is on that.
Well, Your Honor, this court hasn't said that any specific factor is dispositive. I think it has to actually be that the prosecution has to both charge and allege with specificity and prove the allegations. So I think it's actually both on there. And I think that that's a reading of Abby Oden, I believe, Your Honor. But in order for this court to accept the state's position regarding the unit of prosecution, it would have to agree that the unit of prosecution of the statute is defined or is confined to subsection 1A of the statute alone. But that can't be the case, Your Honor, because subsection 1A of the statute does not define a prosecutable offense of child abuse. Subsection 1A sets forth the actus reus of the crime. It doesn't contain a mens rea. So in order for this, so even if the state were correct, it still would not get around the fact that the state elected a pattern theory. So I believe that the Court of Appeals correctly concluded that these counts had to merge the child abuse counts. But I'd like to get to the other issue because I think it's dispositive on all of these issues as well.
Before we go there, can you address obviousness as to plain error? Would it have been obvious to the trial court?
Yes, Your Honor. As the Court of Appeals correctly concluded, we have the benefit of cases like Abby Oden and Weinreich that show that the statute's actually defined in the disjunctive such that it's committed in an alternative way, or that that you can commit it in alternative ways, but it's one offense. And so there's no case or anything on point that suggests even remotely the opposite. So I think the language of the statute in the charging document would have shown that this was just basically a theory that my client violated the statute in multiple ways, but not multiple times.
There's been so much, were you going to follow up on that? There's been so much activity in this area over the last year or so. Does any of our recent case law suggest that it's understandable that the trial court might have been confused and perhaps it wasn't so obvious?
Well, no, Your Honor. The cases to which I refer to were in existence.
No, I know.
And this
My-
court,
Go ahead.
sorry.
No, I said my question still stands. I understand that those are cases that predate the recent line of cases, but I'm just wondering whether there's anything about the recent evolution that's, suggests that that older case law, was off in some way, and therefore the trial court was understandably, maybe it wasn't so obvious after all.
Well, as to the issue I just talked about, none of the recent cases, I think, touch upon that. If I understand Your Honor's question, and I think I see where you're coming from, you might be referring to Rock and Reina Barca and so forth. That would impact the second issue, the lesser and included offense issue, which I've also argued in the brief. Now, it's true this court did clarify the test. However, at the time of trial, Armentrout was in existence, Garcia was in existence, Brown v. Ohio was in existence. And basically the test has been clarified, but it has always been that if you prove the lesser in virtue of proving the greater, that is, if by proving the greater you necessarily prove the lesser, then that means that the lesser offense is an included offense under the test. That's always been true. And I say that here for a simple reason, Your Honors, is that it is impossible to commit child abuse murder without committing child abuse. As this court clarified in Rock, when you have a lesser offense defined in the disjunctive, like child abuse, such that it can be committed in alternative ways, all that matters is that one of those alternatives can be proven by proof of the greater. As this court stated in Rock, in order to be included, every alternative way of committing a lesser offense, only one of which is required, therefore need not be contained in the statutory definition of the greater offense. To be an included offense, it is enough that any particular set of elements sufficient for conviction of that offense be so contained. And that's Rock at paragraph 16. Now, that applies here because if a prosecution or the prosecutor proves that the defendant knowingly caused the death of a child under 12 and is in a position of trust with respect to that child, that prosecutor will have proven that the defendant knowingly or recklessly caused injury to the life or health of a child under 16. That is, the prosecution will necessarily have proven at least one of the alternatives of child abuse. And as I've said, all of the facts supporting the child abuse murder count are the same pattern, same course of conduct for all of the child abuse counts. We do not have distinct acts here. And so therefore, they should all merge with the child abuse murder provision or murder count.
So what's your response to the Attorney General's reply, I think it was the reply, about how the pattern element makes it different?
I have a couple responses to that, Your Honor. There is no distinct pattern element.
Okay.
The offense is defined in the disjunctive, meaning that the element is all of the disjuncts, any one of those combinations. And that's what I get from Rock and Armentrout in cases like that. Secondly, as this court has routinely stated, you do not look at the specific allegations in the charging document. You look at how the legislature defined the offense. And the legislature defined the offense here in the disjunctive with the alternatives. So it does not matter that the pattern does not appear in the definition of child abuse murder. Moreover, it's a little bit unclear what the state's arguing, saying that it's not that the pattern is not included in child abuse murder, because I think that the prosecution can prove child abuse murder through a pattern. So it's not that child abuse murder cannot be committed by a pattern. It's certainly included in that sense. So that would be my response, Your Honor.
Thank you.
As to this issue, the murder of the child abuse and child abuse murder, I think you've suggested that, well, you just cited Rock. What about the plain error obviousness on this one?
Well, I would cite to Armentrout for that proposition, Your Honors. Armentrout similarly shows us that when the lesser is defined in the disjunctive, all that matters is that one be proven, because it's just alternative ways of the same offense. There's no distinct element of one of the specific disjuncts. And further, as I've said, Brown v. Ohio and all of the tests before just show that a lesser offense is included if it is necessarily proven by proof of the greater, which we have here in child abuse. So the test has never actually, even under recent reformulations, made that unclear.
So to be clear, you're relying on the Rock argument and not so much on the statutory interpretation with respect to the exception language?
Well, no, Your Honor, I believe foremost that the legislature has shown through its language in subsection 7A, Roman numeral 1, and 7C in the child abuse statute that it did not intend for a defendant to be twice convicted of child abuse and child abuse murder for the death of the same victim because of the accept that language. This court has said in cases like Abiod, and really the first stop is look at the language in the statute, because the double jeopardy test, the Blockberger test, is really sort of a substitute for legislative intent where it's unclear. Here, I think it's clear that the legislature did not intend for those multiple convictions for the death of the same victim. However, I also believe that as a matter of Rock and double jeopardy, that the counts should merge. If there are no further questions, Your Honors, I'd like to reserve the balance of my time.
Holman?
May it please the court, I'm Matthew Holman, and I represent the people in this matter. I'd like to start by first addressing the question of whether the child abuse resulting in death count merges into the first-degree murder count. And I'd like to focus on what's called the corollary to the subset test that was articulated in Rock, which is the corollary to the subset analysis is the proposition that if establishing the elements of the greater offense necessarily establishes the elements of the lesser offense, then the offense is included in the greater. Now, I don't think I really addressed it in the brief, but in the briefing, but I would disagree that the element in the murder count, which is the knowingly causing the death, necessarily proves or establishes the knowingly causing injury to the health or well-being of the child.
Well, isn't death related to the health or well-being of the child?
I disagree, and then here's why. Under the statutory definition of injury that applies, which is bodily injury, an injury is defined as physical pain, illness, or any impairment of physical or mental condition. Now, one could knowingly cause the death of someone without knowingly causing an injury of that type. For example, if someone wanted to kill someone in a way similar to euthanasia, using a painless method of causing death, they might knowingly cause the death, but they don't necessarily knowingly cause the infliction of injury, which are, again, are those things, physical pain, illness, or any impairment.
What about the relationship between death and health?
Well, health is, I think, defined as, under the statute, as I think the case is talking about mental well-being as much as physical well-being, and I would say that sort of fits into an impairment to health. And I think that's also a distinction, which is an impairment involves a diminishing of a condition, so that if it's an impairment of health, it's a reduction in health. It's not, the removal of life is not the equivalent of a diminishing of health. So I think they're focused on different.
I'm sorry, Mr. Holman.
No, that's fine.
Good morning to you. I may be missing something, and maybe I just didn't hear you, but the statute, the child abuse statute starts by saying person causes an injury to a child's life or health.
Oh, life or health. I apologize. Life or health.
Yeah.
Right. And again, it's an injury to the life or health. So it's either infliction of pain or illness or an impairment of their physical or mental condition. It's not the elimination of those things. So I think there's a distinction there in in the statutory language.
So then what do you do with 7A and 7C? I mean, 7C specifically says when a person causes death of a child who has not attained 12 in position of trust, such person commits the crime of murder as in first degree described in 18-3-1021F. Doesn't that directly express the legislative intent that on these facts the crime is murder, not child abuse?
I think when one knowingly causes the death of a child who is under the age of 12 and they're in a position of trust, what the statute says is that is addressed in the murder statute. That is not encompassed within the child abuse statute.
And isn't that the end of the argument?
No, I disagree, Your Honor. And one of the reasons is I think my opponent is making a connection between that section, which I think just clarifies that situation is covered by the murder statute, versus saying it somehow encompasses and removes all of the child abuse counts. I think that section doesn't appear in the offense section of child abuse, which is the 1A section here. And also, it doesn't say that particular offense essentially envelops all of the others. I think that if that's what they meant, they would have said that, I think, in the statute, which is that if ultimately this constitutes this crime, none of these other sections apply. But if you look at where they put it in the statutory section, I think they were concerned that someone was going to think that somehow there was an equal protection problem, perhaps, that if you knowingly cause the death of a child, it might be a murder or it might be child abuse. And so I think all they're trying to clarify is that difference. And also, I think that goes back to the broader principle of the child abuse statute, which is that it doesn't go to the result. The mens rea goes to the act of child abuse. Did you knowingly cause the injury to the health or life of the child versus did you knowingly cause the death? And I think those are legally distinct.
So I'm sorry to keep interrupting
no.
you. Could you address Mr. Gravelius's argument that 1A doesn't have a mens rea in it, and therefore you've got to read 1A and subsection 7 together to define the offense of child abuse?
Well, I think you have to read those mens reas into the elements of the statute. I think that's correct. I think my point, which relates to the unit of prosecution, is that when you look at the unit of prosecution, it is the knowing infliction of the specific harm that constitutes the unit of prosecution. And if that results in a serious bodily injury or death, obviously that affects the class of the felony, and that would need to be proven. But in the unit of prosecution, it's not required.
Thank you.
I hope that answers your question.
You did. Thank you.
All right.
Mr. Holman, do I hear you to abandon the pattern distinction that you were making in the reply?
Oh, no, not at all. But before I get to that, I will say one thing, which is if you all agree with me on the first part, which is that the knowingly causing the death does not necessarily establish knowingly causing injury, that's dispositive of the issue entirely. None of the child abuse counts would ever merge into the murder of a child count because they have those distinctions. But no, I stand by the pattern of conduct. That is what the charge here was. And I don't read Rock as saying that all of the alternative, even if the one you charge is not a lesser included and you're convicted of is not a lesser included, that if you can find another one under a variation in the statute, that therefore it becomes a lesser included and it's essentially subsumed into the greater. So I would stand by that position.
So I'm sorry, Mr. Owen, I'm not sure I'm following the argument well. Wasn't the whole purpose for Rock to clarify Reina Abarca to say when the lesser can be committed in alternative ways, as long as any of the ways fit the greater, we're okay? I mean, the argument that the pattern argument you're making, at least when the Court of Appeals addressed it, was the Blockberger test. Each crime had an element different from the other, which I think we've clarified in Reina Abarca and Rock and Page.
Well, and I could be wrong, but I didn't read Rock as going as far as that. What I read Rock addressing is essentially the situation perhaps that arose in other cases like Meade, where we said, well, there's an aggravated theft, but the motor vehicle theft isn't a lesser included offense because it has this specialized version of the element, which is motor vehicle theft. So I read Rock as saying that you don't, those alternative ways for the lesser don't preclude it being a lesser included offense. But I think what Rock says is a conviction for an offense that is a lesser included offense and the greater must emerge. So I think, again, it looks to that particular count on which the conviction relies. So again, this one includes the pattern of conduct as an element of that, and that definitely distinguishes it from the greater murder of a child.
But the Court of Appeals also relied on the fact that the first-degree murder count also requires a child under 12 and somebody, the defendant, in a position of trust with respect to that child. Are you relying on that as well?
You know, at the beginning of the briefing, I was relying on the fact that a child under 12 is not a subset of a child under 16, but my reading of the case law following Reyna Abarca, including Rock, is that it would be considered a subset, that particular element, so that by proving that the child's under 12, you also have proven that element.
What about the position of trust? Is that relevant at all?
I don't think it's relevant here because I don't think it's not required for the lesser included offense, so I don't see that it matters. Again, I would say, again, my main distinction would be the knowingly causing death is not necessarily established knowingly causing injury under the child abuse statute. Oh, and I would like to address, I think Justice Samore was discussing about whether, so we have the discrete acts on the 13th and the 14th, which is one is striking the child so that she hits her head into the doorway, and then the discrete act on the 14th, which is the striking of her head and she flies into the bed and onto the floor that's thinly covered with carpeting. So I think those are the discrete acts. Now, I think for the pattern of conduct, while you may not need to, you can include those in determining whether a pattern is proven for the separate count of child abuse resulting in serious bodily injury pattern of conduct count. I think what the evidence showed was we had those two acts, but surrounding them were additional strikings of the child in the head. The child became unresponsive on the first day, I believe, and she also vomited that day. On the 14th, I have to keep track of these. On the 14th, she was struck again by her mother, and then also she was struck by the defendant in addition to being struck when she flew off the bed. He also threw her onto the bed physically. Now, both the coroner and the neurosurgeon in this case talked about the cumulative effect of multiple injuries here. And so, and going back, they also testified that that those two discrete events, the doorknob event and the bed event, would account for her skull fractures and her subdural hematomas. Then both of them also testified about how the cumulative effect of after suffering a head injury, being repeatedly struck in the head, will aggravate your injuries and bring on additional injuries, and we see that in this case. So I think, I'm sorry.
I'm sorry, if I could interrupt. In the briefing, you focused on the failure to provide medical care as part of a pattern. Is that?
That's also part of this.
Could you expound on that a little bit, because, and maybe identify where in the record the prosecution identified that as a discrete pattern?
Well, first of all, I would say that I believe it was the coroner spoke about the lack of treatment causing these additional problems, the stopping of breathing, the seizures, the vomiting, all of those things. So it was identified as a cause of her injuries. Pardon me, by the coroner. I think the prosecutor in closing talks about those things as showing a pattern of conduct, that there's a lack of treatment and medical care at that point, and points out that the defendant, in fact, when the EMT showed up, told them an untruthful reason for her injuries, that she just slipped on the ice and essentially obstructed her care. So I think.
So in arguing that, though, did the prosecution actually rely on that failure to provide medical care as a discrete pattern of conduct distinct from the blows to the head and the hitting the bed and that kind of thing?
I think they identified it. I'm not sure how much they described. They went through the elements and said, and this is the additional acts that support the pattern of conduct. But I think the way the jury was instructed in the arguments they made identified that as an aggravating or additional problem that caused her serious bodily injuries.
If that lack of medical care were sort of taken off the table here, do you agree or disagree with your opponent that a pattern of conduct could be based strictly on the discrete acts, that you could charge and convict of discrete acts and then combine those acts and separately convict the defendant of a pattern based on those same acts?
I would say in this case, no. I think that those discrete acts, if we just take the head injury on the 13th and the head injury on the 14th, that those do not necessarily constitute a pattern of conduct that cause cruel punishment or mistreatment. I think you, as he said, you can do, and as they did here, you can look at a group of these acts together and say, yes, there is a pattern of conduct here that caused the serious bodily injury. And this reminds me, I believe it's the case of Dunaway. I think it's that case, which talks about, it's a situation where the defendant, there's sufficient evidence for one theory of child abuse, but there's not sufficient evidence to show that through lack of medical treatment, and they don't call it a pattern count, but lack of medical treatment caused serious bodily injury. And this court points out, which I think is significant here, is that there wasn't any evidence there to show either that the injuries that existed were aggravated by the lack of immediate medical care, or that additional injuries occurred. And I think the evidence here shows that situation arose here, which is both the doctor and the coroner testified that these repeated strikings of the head would exacerbate her injuries and cause additional injuries to her. So I think there's evidence that supports giving that and finding that count on the pattern of conduct.
Mr. Holman, while you've paused, let me ask, same question I asked Mr. Gravelius. What do we look at in terms of, do we look at just the complaint or the information, or do we look at how the case was presented? And I guess what I'm asking you to do is address Mr. Gravelius' argument here. The prosecution presented us all as one child abuse count. If you look at the counts in the complaint, they're all mixed and matched together. There's no specific incidents tied to anything. And when they presented it the same way. So could you address that?
Sure. Well, first of all, I think you do look at determining whether there were discrete units of prosecution here. You look at the statute, and then you look at the evidence that was presented and the factual components, and as we all know, whether there are separate volitional acts or breaks in time or relocation of the victim. Those things are all significant in determining whether they're separate acts as far as units of prosecution.
Is the information relevant, though, too? I guess my concern is we could get a constructive amendment problem if the complaint is totally irrelevant.
I'm not sure that the charging document makes a difference here. I think it could, but I don't think it does here. I think one is there are specific dates for the different acts and which periods of time they encompass. And I guess that would be a good point for me to point out that, and responding to something you said earlier, which is in closing argument, the prosecutor makes clear that the two discrete acts are those discrete acts and what they are. He says The one on the 13th is the doorknob incident, and the one on the 15th is, or 14th is the springing off the bed incident. He's identified those. The evidence supports those independently of all the other charges. I think also there's enough evidence here that the lack of treatment and the continued and repeated abuse supports the serious bodily injury count. Honestly, I have a little trouble distinguishing between the two child abuse resulting in death and child abuse resulting in death pattern counts. I think that's a little more nuanced. But I think you can still find that those are different, partly because you can see a pattern of a lack of medical treatment that results in the obstructing of medical care where the defendant lies about what was the cause of her injuries. So I think there's a pattern there that flows through. And I think that the child abuse resulting in death, you could say, well, he struck her in the head again on the second day. This seemed to lead to her unconsciousness and inability to breathe, becoming unresponsive, and ultimately dying. And I think again, the doctors indicate that those things all exacerbated her injuries and led to her death.
Is it possible that the jury, with respect to count 6, relied only on the incidents that you've described with respect to counts 4 and 5, the door incident and the bed incident?
This is the child abuse pattern,
Right.
death count?
Is it possible, and is that problematic?
I don't know that it is possible. I mean, I guess that would be a question about what is a pattern of conduct that results in all of these things, and I think the prosecutor isolates which ones he's talking about, the lack of medical care or punishment. I think we assume that they apply those as they're instructed, and so I'm not sure that there's a problem there. I have trouble seeing how, with the encompassing evidence and the prosecutor's sort of presentation of it, that they would necessarily only consider those two acts and not look at the overall situation in determining that there was a pattern of conduct here.
The verdict forms didn't specify it, though, right? And the instructions didn't either. I mean, they did with respect to counts 4 and 5. They didn't with respect to count 6, right? It just said pattern.
That's correct, yes. It is. And then I think, unless you have some other questions, I just wanted to briefly address the plain error question that Justice Hood raised, which is, I think this is a case where there should not be a finding of plain error. And I think, Justice Hood, I think you referred to the recent cases from this court on Reyna, Abarca, Page, and Rock, and I think those, one is confirmed that these kinds of claims are not waived when they're not raised, but are subject to plain error review. I think the trial court may have assumed that by them not being raised, they were essentially being waived by the defendant at that point. So I think the fact that the court might have followed one line of law, I know this court pointed out that there was a strong disagreement about waiver versus plain error. So that alone might be enough to get us to finding there's not plain error. But also, when you look at the Court of Appeals opinion here, both sides asserted that there were 3 ways of committing child abuse. The court found 14. The court made several determinations about how those operate and presumed that it was one continuous act. I'm still trying to figure out if they think the unit of prosecution is the ultimate injury or if the unit of prosecution is the child under that sort of one encompassing offense. But apparently that was not known. I would say there's case law that seems to look at alternative theories under the statute versus one encompassing act. The jury instructions that existed, the model jury instructions, distinguished the crimes in that manner so that there were 3 separate counts. So all of that being said, I think it's hard to say that the trial court would have known obviously that the statute would operate the way the Court of Appeals contemplated it. And I think in a case like this, where there are multiple acts over several days, that it was not obvious that they should all be somehow merged into one count. If there are no further questions, I would thank the court for its time.
Let me ask you a clarifying question. I asked opposing counsel about this. On page 35 of your brief, it's actually pages 34 and 35, you talk about counts 4, 5, and 6. And you talk first about the evidence that you think supports count 4, then the evidence that supports count 5. And as to count 4, you talk about the door incident. As to count 5, which happened on January 13. As to count 5, you talk about the bed incident, which happened on, I think, January 14, 15. And then as to count 6, the pattern, you say that later, on the night of January 13, the defendant knocked MB unconscious. Was that an incident separate from the door incident?
That is my understanding of the record, yes, Your Honor.
Okay, and then you go on to talk about the failure to seek medical assistance, correct?
Right.
So the way I read your brief, as to count 6, you were saying that that pattern count is only supported by evidence that's not related to counts 4 and 5. Are you saying today that count 6 was also supported in addition by the evidence that supported counts 4 and 5, and that that's okay?
I think I am, Your Honor. I think you're correct. I sort of, at the time, thought, well, the acts should be independent of the discrete acts, but I think you can look at them as an ongoing multiple acts that demonstrate a pattern of conduct, and it can include those acts. Again, I would say sort of the thing that seems significant to me in proving those pattern counts is that the additional conduct either aggravated the injuries that existed from the discrete acts, or added additional injuries, which is what the record demonstrates here. And I think you can include all of those acts together to show a pattern of conduct resulting in other forms of serious bodily injury. I don't think they're all subsumed by the death of the child. I think she suffered individual harms as a result of these things, and I think provided they support the finding of a pattern that led to serious bodily injury, that's fine.
So if I could just sum up, am I understanding you to say the pattern, count 6, is comprised of the count 4, count 5, plus additional conduct that may have aggravated those injuries?
I think it can be supported that way, yes. I think that's fine to do it that way.
But did the government argue that in this trial? I sure don't remember it. Did the prosecution argue that in this case? You're making, you're a smart lawyer, you're making a good argument now, but I don't recall that in the record.
Well, I would say in closing, he discussed the discrete acts, and then he talked about the pattern count, and then I would say he quickly just slipped through the child abuse death counts. On the other hand, he put on evidence that he put on 2 experts at least who distinctively talked about, and is there a cumulative effect that happens when a child is struck over and over after they've already suffered a head injury? And both of them talked in detail about what those were. So I can't see that he's obligated to make sure that he mentions every way every count is charging.
But didn't he in his closing, with respect to the pattern count that Justice Marcus was asking about, only argue the door incident and the bed incident?
I think he just sort of said it as a group, that there were all of these conducts led to this. I don't think he distinguished just those. I don't think he relied just on those 2.
Okay, thank you.
That's my recollection.
Thank you.
And even if that's the case, let's assume you're right, and let's assume that the prosecution argued everything with respect to that count 6. How do we know that the jury didn't go back during deliberations and just decided that the ones they believed that constituted the pattern were the door incident and the bed incident?
Well, I suppose 2 things which go with presumptions about juries following instructions. One is there's a unanimity instruction which told them they had to unanimously agree on the act or acts that support the conviction. The other is that that the elements of the different offenses are distinct, and they include this pattern of conduct. It requires a finding of a pattern of conduct to convict on that count. I don't think the prosecutor ever said to them, you can rely just on those 2 counts and you can ignore the rest of the evidence. I think instead he was really showing a pattern of abuse over time that ultimately resulted under that count in serious bodily injuries to the victim, and then the child abuse death one also. So.
I don't remember the Court of Appeals mentioning the unanimity instruction. Am I wrong about that? Did I miss that?
I don't remember them mentioning, but it is in the jury instructions.
Okay. I don't remember it coming up in your brief either. Maybe I missed it too.
I didn't, because I didn't think there was a unanimity instruction, but when I was preparing, there is one.
Okay.
There is one in the jury instructions.
Thank you.
All right.
Anybody want to torture Mr. Holman further?
Thank you.
Okay, thank you. Mr. Gravelius, you've got a little more time. In fact, you've got 14-plus minutes.
Yes, just briefly, Your Honors. I want to pick up where Justices Gabriel and Samore were talking about count 6 and whether the jury could have used evidence from counts 4 and 5. And the answer to that is yes. And the reason for that is, as I've briefed in my answer in reply, is that at every turn in this case, the prosecution has treated this as one course of abuse, not multiple patterns, but one. I think in sentencing, I'll go backwards, but in sentencing, the prosecution conceded that counts 2 through 6 were based on the same evidence and agreed with the court that they had to be at least concurrent. In closing argument, and I'm not going to read all of closing argument to this court, but I would ask this court to really look at pages 38 and 39 of the August 26th transcript. Beginning on page 38, the prosecution goes through the evidence supporting the first count, the murder count, stating that when you add up all the combination of strikes, blows, and hits, this is what resulted. As to count 6, the prosecution concludes pattern, same thing, it's a continued pattern from the 13th through the 15th. At every turn in this case, the prosecution declined to differentiate count 6 or any other pattern or course count from the other ones. And so there only was one pattern, Your Honors. Regardless of how the evidence may be hypothetically parsed in hindsight, that is not what happened below. Everyone agreed, one pattern, that is it.
Can I ask you a question about the way these various alternatives are phrased? Do you think there's any difference between causing something and engaging in conduct that results in something?
I mean, off the top of my head, it's not really clear to me, Your Honor. I mean, because in a sort of loose sense of cause, engaging in conduct that results in something would be a cause. I'm not really sure what the distinction would be, Your Honor.
No proximity of cause required, or you think any difference between those two?
It might be, and this is, I just hazarding a guess, which I'm reticent to do before this court, but the latter might try to broaden the scope of causation such that it's not as direct, maybe not necessarily proximate, or I'm not really, it could be that way, Your Honor.
Let me ask one more on that. Apart from various acts that would constitute child abuse, do you think, what would be your argument with regard to a separate charge, say, of assault or a different kind of murder, but that still resulted, that would fall within the pattern that was also charged as, engaging in conduct that results in this kind of injury to the child?
So if I understand Your Honor's question, like take a case similar to ours, but maybe that there was an assault count included within that.
Suppose they had charged in this case one of the head injury cases as an assault.
Well, not really looking at the assault statute. I don't know whether that would be an included offense. There may be some issues there. I'm not really sure. I'm not saying that the child abuse statute itself would preclude that as a possibility, as a matter of legislative intent. I think it would for murder, but that's another matter. But as far as legislative intent on that, I don't see the legislature necessarily precluding like an assault count.
Since you say that about murder, let me ask one more about the 7C then. It does seem a little peculiar that you have a situation in which in the child abuse statute there is a reference to the murder statute, and actually it doesn't say this would be incorporated in or anything. I guess where I'm going is there is a flavor in the prosecution's argument, I think, that this provision in 7C actually is intended to distinguish this kind of causing death as a murder from the other descriptions of child abuse. Do you have any thought about that?
I think that could be a plausible reading, but for the fact that the legislature used the "except that" language, showing that you can't be convicted of both child abuse and child abuse murder. I think that that shows that the legislature is specifically showing that one is a very specific and egregious form of the other, and that you cannot have convictions for both.
Okay, thank you.
If there's nothing else, Your Honors, I
Actually,
ask.
if you- before you step away, I'm going back to your comment about the August 26th transcript where the prosecution relied on the entire combination of blows, strikes, and hits as a pattern. Is it your position that a defendant could not be convicted of a pattern where the pattern included this discrete acts plus some series of other conduct in addition? Is it your position that anytime a pattern includes the discrete acts, you can't be convicted of both the pattern and the discrete acts?
If the discrete acts, Your Honor, are wholly subsumed within that pattern, then that is my position.
Even if the pattern includes additional conduct?
That is correct. If the pattern includes conduct beyond the discrete acts, such that, it's the discrete acts plus, let's say, I do not believe the defendant can be convicted of the pattern plus those discrete acts. That is my position.
Thank you.
So I hesitate to ask this, but sort of the elephant in the room is what's the practical benefit for your client of prevailing on your arguments? He's still doing life without parole on child abuse murder, and presumably, at least I'm having a hard time imagining how it might affect post-conviction review. So I'm not sure that it matters, but I'm curious.
Well, Your Honor, truthfully, I don't have a great answer for this court. It may affect things like housing status and the DOC, but as Your Honor put it, he will still be doing life without parole regardless.
All right, thank you.
If there's nothing further, I ask that this court hold that my client should only remain convicted of count one. Thank you.
We appreciate the arguments of both counsel, and the case will stand submitted. Everybody ready to go on? And we'll move on to the next case set this morning, which is People of the State of Colorado, XRL Wolf versus Cease. And we'll give a few minutes for counsel to take their places. We'll give a few minutes for everybody to take their places. All right, so the next case we've got set for arguments, People XRL Wolf versus Cease, I believe. We've set this one for a half-hour total argument. As I was reminding the other counsel, because we record these, when you come up to the mic, if you would announce yourself and indicate who you're representing and try to talk somewhere near the microphone during the course of your argument. Thank you. Mr. Schwiza, you want to go ahead and get started?
Good morning. Thank you, and may it please the court. I am Eric Schwiso, registration number 23385, representing Greg Cease, Robert Greg Cease, in this matter. I want to start off by looking at how the order that forms the basis for the proceedings that we are here is not written The order is not written in language of thou shalt not suffer the following acts to occur. The order is actually written, and I'll quote from the order, defendant Robert Gregg Cease, whether acting individually or through his agents, blah, 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 is ordered to do nothing whatsoever, directly or indirectly, in, along, or to Sheep Creek, is ordered to do nothing whatsoever in or along Sheep Creek. So that's part A of the portion of the order that's at issue. Part B, the defendant Robert Gregg Cease, whether acting individually or through his agents, servants, or employees, is ordered to not construct, maintain, or encourage the development of, and then it goes on to list a number of things. So again, it's not that he is ordered to prevent things from happening on his property. He is ordered to not do things, and it is therefore not a strict liability statute. You'll recall out of some of the cases citing in the briefing, particularly the Vaughn case, there was a question about whether the ability of the state engineer to issue cease and desist orders and those orders not being followed resulted in strict liability of the well owner in that case. And this court said, we don't have to address that because the issue that was addressed both in the trial court and the lower court was that there had been action, there had been agency on the part of Mr. Vaughn to cause those things to happen. Here, the state wholly failed to prove that action and that agency. I think it's worth quoting from Division Engineer Craig Cotton. This quote is set forth on page 14 of my brief, who testified, there was one person that we understood that did the work, and he was on our witness list, I believe, but we were unable to locate that person. And then I asked him, you cannot state with certainty that Mr. Cease is in any way personally responsible for any of the acts that you allege are in violation of the court order as alleged in the motion for contempt and in your affidavit, can you? And Mr. Cotton's answer is, I have no personal knowledge that Mr. Cease was personally responsible for that. The reason this is important was stated in the opening of the briefing, and that's because the fourth Nussbeck factor is the only issue that is at issue in this case, the only issue that was at issue in the trial court. And that fourth factor is the contemnor's willful refusal to comply with the order. The state needed to prove that Mr. Cease is the individual responsible for the numerous violations of the order that took up the entirety of the hearing. And the state introduced precisely no evidence of that fact.
Are you arguing that circumstantial evidence is never enough?
No, absolutely not. And in the briefing, I acknowledged that circumstantial evidence is enough. So
go ahead.
What I'm arguing is that the state didn't even produce circumstantial evidence. And the reason that is the trial court instituted a chain of reasoning that said, I'll quote it off of page 238 of the transcript, the court finds Mr. Cease is the owner of the property. There is no question about that. And that a reasonable inference from the fact of his ownership is that he was aware of them and approved of them being the violations on the property, or that he did them himself. And what I'm saying is, in fact, the state did not introduce any evidence that would show that Mr. Cease was the owner of the property.
Well, let's look at the totality of the evidence here. We have 7 separate contempt citations against your client over a long period of time. We have admissions in an answer the property was his. We have times where he admitted that he didn't do particular work. I think the court also said, or I think I'm remembering, who else would have done the work? I mean, how this work required front-end loaders and equipment on this guy's property, and the court seemed to say, really, that the person who owned it had no idea those people were on his property and they were just on there for their own sake and didn't get paid? Why is not that composite of evidence enough to get you an inference?
Because you have to start that inference right exactly where you started it just now in your questioning. The person that owned it didn't do all this stuff, and it's that key piece of evidence, the person that owned it, that is entirely absent. So I agree with you. The record reflects that in 2007 and 2008, Mr. Cease owned the property. There's a stipulation that recites that fact. But the incidents that we are talking about occurred in the fall of 2015. So they occurred 7 and 8 years after there was ownership established. And we don't know, the trial court did not know, does anyone else share ownership of that property? Is there anyone else who has an interest in doing work on that property, maintaining that property, keeping that property up? Is it jointly owned? Is it owned by a corporation? Are there people with long-term recreational leases on that property? Is there anything that would indicate that Mr. Cease in 2015 still owns that property? And there is not. And Your
Did you
Honor,
contest it? I recognize the burden of proof argument that you will get to. Did you ever contest ownership? I mean, the issue, or my concern, I'm just pushing on you here, so push back. We've got 7 years of admissions of ownership. Without hearing anything to the contrary, why can the court not rationally infer he still owns it?
Well, I think the only answer to that question is to get into the burden of proof. So it is incumbent upon the state to prove every element of the offense. There's no dispute about the 3 elements, so it's incumbent upon the state to prove that 4th element, and the state knows going in that they have a problem with proving that. They thought they had the guy who could say, Mr. Cease hired me to do this kind of work on the property, and I did it for him. That's what Mr. Cotton's testimony seems to indicate. They thought they had a guy who could do that. They didn't have a guy who could do that. And so if they don't have the guy who can tie Mr. Cease, to the work being done, then they have a serious problem and they need to solve it. And it's easy to solve. You can have self-authenticating records out of the clerk and recorder's office or out of the county assessor's office that would simply show who the owner of that property was and whether there was only one owner or whether there were more owners or what the ownership structure was. It was incumbent upon the state to do that, and they didn't do it, and so therefore the initial stone, the initial link in their chain of evidence doesn't exist. The initial link in that chain of evidence upon which, circumstantial evidence, upon which they ask the court and upon which the court did make a conviction is merely an assumption.
Shuizo, wouldn't the fact that there's a proof of ownership in 2007 and 2008, because you can see there's a stipulation as to ownership at that point, is that not also circumstantial evidence?
I don't think that logically that evidence has any import on whether that ownership is the same in 2015.
Well, that's really the weight that the court may want to give to it, but it is circumstantial evidence that he owned it. Is it not?
It's certainly, it's not even circumstantial. It's direct evidence that he owned it in
Well,
2008.
I'm saying,
but
isn't it circumstantial evidence that he owned it at the time in question?
no, I don't think it is. I don't think that you can make that logical leap. And if
Why? Why
well-
can't you say if he owned it yesterday, he probably owns it today? The facts and circumstances of the fact that he owned it yesterday is evidence that he owns it today.
Well, are you going to shift then the burden to the defendant to prove that he does not own it today? I think that's part then of the burden shifting problem.
But aren't we talking about, you're talking about, I think it's apples and oranges. Tell me why that isn't just the weight of that the trial court gave to that circumstantial evidence.
I don't have a good answer for you as to why that's not the way, other than the fact that if that is how the state is going to prove ownership, then you have shifted the burden to the defendant to disprove that that is true.
Why is that a shifting of the burden and not the weight? I guess I'm not trying to be argumentative. I don't understand. If the trial court had said, and he didn't prove that he didn't own it, that might be something different. But if you look and say he owned it at this time That's circumstantial evidence.
Okay.
And I find that, I'm speaking as the trial court, and I give weight to that. It seems like you're arguing that he shouldn't give weight to that.
Well, I think that, let's put it this way, if you give weight to it, I believe that Diaz says that there has to be enough other evidence in the record that you have refuted every other reasonable hypothesis about what's going on, because that's the holding of Diaz. If you're relying on circumstantial evidence to tie the defendant to the crime, then that circumstantial evidence has to negate every reasonable hypothesis about other causes for that. And
Hasn't that standard been flatly overturned?
hasn't that standard been flatly overturned?
Yeah, at least with regard to criminal law. Haven't we expressly said that, and with regard to a motion for judgment of acquittal, that there's no distinction between circumstantial evidence and direct evidence for purposes of test? And the old, you have to eliminate all other alternatives, is no longer the law in Colorado.
Well, what got overturned, my understanding, and I may have overlooked a case, which is embarrassing, but my understanding is that what was overturned was the notion that you have to eliminate every other possible hypothesis.
I'm sorry, I thought that's what you were saying had to be done here.
No, you have to eliminate every other reasonable hypothesis. So there can't just be a fanciful expectation that something else could have happened.
So you don't take Bennett in whatever that was, 72, a couple of years after Diaz, you don't take that as overturning the dispute alternatives, demonstrate the lack of viability alternatives test for circumstantial evidence. You feel like after Bennett, there still is a distinction between circumstantial and direct evidence?
I do. It's the danger of relying purely on the circumstantial evidence, I think, is illustrated by Justice Boatwright's question, which is, isn't it a question of how much weight you give to the evidence when there really is no evidence that would support independently a conclusion that establishes the first link in the long chain that gets you to the hypothesis?
Can I ask whether, just thinking about it from the perspective of the district court, and I'm really am not suggesting that Mr. Cease had the burden of proof on ownership, but several times during the hearing, Cease's attorneys referred to him as the owner of the land. They didn't react when she said that there's no dispute about the question of ownership. Was the trial court entitled to therefore taken with the fact that he had earlier conceded that he owned the land, does that affect the weight she could give that earlier concession? And I think relatedly, doesn't that mean that this issue was not preserved for appeal? The trial court never had a chance to address this because it was never raised at the trial court.
Well, I don't think that issue, I think that issue properly understood really would put the burden on the defendant to file a motion for reconsideration before filing an appeal, because the defendant's argument is that the evidence upon which the trial court relied was insufficient. And it's not incumbent upon the defendant who may be looking at an appeal to point out to the trial court where the prosecution's evidence is insufficient, other than in closing argument, which is what the defendant did. The defendant said, there's no evidence that Mr. Cease did that. And when the defendant said that, the prosecution didn't turn around and say, oh, yes, there is. There's all this evidence of his ownership. The trial court just assumed that there was ownership, and neither the prosecution nor the defendant raised that issue. But for the defendant, it's a question of sufficiency of the evidence.
Well, what about references that weren't expressly designed to prove ownership but may have indirectly done so? Weren't there some references in the EPA restoration plan and in the water engineer's testimony to the Cease property?
There was a reference in Exhibit C that Mr. Bennington pointed out in his brief, that where the author of that plan said the plan will work on the property that is owned by Mr. Cease. I think that's hearsay evidence. There was no move to introduce that on the part of the prosecution, and it didn't. No party took that as any kind of evidence whatsoever, and neither did the court. I see I'm out of time. I'm certainly happy to continue to be the recipient of your questions.
All right, hearing none, we're going to give you the hook. Mr. Bennington.
May it please the court, I am Paul Bennington, First Assistant Attorney General for the state of Colorado, attorney registration number 33079, representing the state engineer, Kevin Ryan, and the division engineer for Water Division 3, Craig Cotton. Your Honors, I want to go directly to some of the issues you were questioning Mr. Cease about. As you know, the trial courts have broad discretion in establishing contempt of court procedures as long as they accord with due process of law and protect the constitutional rights of an alleged contender facing potential punitive sanctions. The water judge properly issued a contempt citation to Mr. Cease to appear to show cause to the water court why he should not be found in contempt of the water court's 2013 order. That order was served with a contempt citation and included a map of the Cease Ranch entitled Map of Greg Cease Property, unquote. From the beginning to the end of this case, including the latest contempt proceeding, Mr. Cease's ownership of the Cease Ranch has remained undisputed. His answer to the original complaint admitted his ownership and was never amended. A later stipulation to the fact of his ownership was made binding in the case for any later proceedings just like this one, and Mr. Cease never sought to have that stipulation set aside or amended.
Is that the 2007, 2008?
That was 2010, I believe, Your Honor.
2000, all right, thank you.
For the seventh contempt proceeding, the record shows the water court protected Mr. Cease's due process rights by holding an advisement hearing to advise Mr. Cease of his constitutional rights and to take his plea, by setting a 2-day trial, by entering case management orders with deadlines for mandatory disclosures, because we're under the rules of civil procedure, expert reports, pretrial motions, and discovery, including depositions of both the division engineer and Mr. Cease's expert witness. For his initial mandatory disclosures, Mr. Cease was required to identify all documents relevant to the claims and defenses of either party. In his first disclosure, Mr. Cease only identified one document. Mr. Suizo just talked about it. He identified it. The 2014 Second Restoration Plan for Sheep Creek, which was prepared for Mr. Cease by his consultant and identified Mr. Cease as the owner of the ranch. In his second disclosure, 2 weeks before trial, Mr. Cease added one more relevant document, an email chain between Mr. Cease's counsel and me in 2015, explaining how Mr. Cease had removed 2 pipelines and the southern berm after we had caught him with the violations to try to cure his violations of the water court's order. Both these documents, contrary to what Mr. Suizo said, that exhibit about the restoration plan, we moved to admit it into evidence. It was their trial exhibit. They listed it as their trial exhibit C. It was a complete copy of the plan. We moved it into evidence without objection, and it was considered in evidence at the trial. The email chain was also admitted into evidence, but it was limited to showing how Mr. Cotton first learned in 2015 that Mr. Cease had the northern pipeline, but had removed it, and had also removed the berm. When Mr. Cotton went out there in his first site visit, he couldn't see the pipelines. They were buried. He didn't know they were there until we got a response from them saying, oh, Mr. Cease has pulled the pipelines out and set them next to the ditch. That's how Mr. Cotton first learned that the pipelines were even there. And on cross-examination, the transcript shows Mr. Cease asked Mr. Cotton to testify about the contents of that email chain as to Mr. Cease's removal of the previously installed northern pipeline. Thus, evidence of Mr. Cease's ownership and control of the property in 2015 exists in the trial record as a result of Mr. Cease's own trial exhibits admitted into evidence and as a result of Mr. Suizo's cross-examination of Mr. Cotton. Now, Your Honors, Mr. Suizo just talked about how the court said, I find Mr. Cease is the owner of the property. There's no question about that. That second statement of fact is the court stating its understanding of the proceedings to date. There was no question about Mr. Cease's ownership anywhere in the proceedings. Other pretrial proceedings support the water court's conclusion about the proceedings. The state filed a motion in limine to exclude certain testimony by Mr. Cease's disclosed expert, Dwayne Helton. In response to the state's motion, and this is just 1 week prior to trial, Mr. Cease's counsel informed the water court, quote, Mr. Helton performed a field inspection of defendant's Sheep Creek Ranch on April 16, 2016, and several structures and locations on that ranch regarding the state engineer's allegations, end quote. 5 days before trial and on the first day of trial, Mr. Cease's counsel brings up the email chain, brings up the fact that Mr. Cease removed the pipeline on the northern part of the property, removed the berm on the southern part of the property, invited the division engineer out to the ranch to inspect those removals, all demonstrating in 2015 Mr. Cease's ongoing ownership of the ranch and continuing control of the ranch. The water court knew that. We knew that. Now, they were required by the water court's case management order to disclose all relevant documents related to our claims and their defense. If they felt ownership was still relevant, given everything that was in all the proceedings, they had a duty to disclose documents relevant to his ownership, his deeds, other documents that might show that he no longer owned the property in 2015. You did not hear Mr. Suiso tell you today he didn't own the property then. He doesn't own the property today. In fact, he does. And so the judge's order is not erroneous and should be affirmed by this court. During Mr. Cotton's uncontroverted trial testimony, there was no objection by Mr. Cease's counsel to the foundation for Mr. Cotton identifying the Cease Ranch, the Cease's property, Mr. Cease's house, or Mr. Cease's corral, because everybody knew he owned all these things. The court knew it. It was never in dispute.
Mr. Bennington, who testified to that?
The division engineer, who has been dealing with Mr. Cease for more than a decade.
And has he been on the property?
He's been on the property numerous times. As we said to the court, Mr. Cease probably knows this 1 mile of stream better than any other stream in Water Division 3. He has been out there so many times.
You said
since
Mr. Cease,
2007.
you meant Mr. Cotton?
Mr. Cotton, yes.
Okay.
I'm sorry. Thank you, Your Honor. Yes, he's been
When
out
was-
there repeatedly.
I'm sorry, when was the most recent time when Mr. Cotton's been out there?
Mr. Cotton was first went out there in September of 2015. After this latest order that was entered in 2013, Mr. Cotton went back out there in 2015 because they had heard a report from a neighboring landowner about some activity on the property. That's when he did the site visit and saw numerous structures that he felt were violations of the order. But at that site visit, he did not know about the pipelines because they were buried, and learned about those when we contacted Mr. Suiso to find out if he still represented Mr. Cease. And then we learned that the pipelines, he pulled those out and he was curing his contempt. That was only on the upland sites. That was not on any of the violations along Sheep Creek and really didn't relate to the pond on the northern part of the property or the northeast ponds, number 1 and 2. So Mr. Cease went back out there, I believe in December of 2015.
Do you mean Mr. Cotton?
I'm sorry, Mr. Cotton, thank you, Your Honor. Mr. Cotton went back out there in December of 2015 to see what he could see at that time, and that's where they were able to observe the pipeline had been taken out of the ground and set next to the hole for its entire length, and the southern berm had apparently been changed. We had contacted them because we were concerned about spoliation of evidence. We said, you shouldn't be changing anything out there. We're going to have a contempt of court proceeding. Please don't change things on the property. But that proceeded nonetheless. Now, later in the trial, at the close of the state's case in chief, the defense moved for a directed verdict of acquittal, arguing that nobody saw Mr. Cease or his agents or employees commit the violations. On behalf of the engineers, The trial transcript shows that I specifically argued to the water court in response to that motion that, quote, "Here we have the owner of the property in control of the property under an order that is really remarkable when you look at it." I said it was remarkable because Mr. Cease had stipulated to underlining in the order, "do nothing whatsoever," because we had been through so many contempt proceedings. I believe it was even their counsel that proposed, "let's underline it for my client." And so it's a very unusual order in that regard. I also argued that the ranch was his property and that these types of acts occurring on his property could be imputed to him. In response, Mr. Cease's counsel did not argue that Mr. Cease was not the owner or that we had failed to show he was the owner. Instead, 3 times, Mr. Cease's counsel confirmed that Mr. Cease was the landowner. First, he argued that the contempt of court rule, Rule 107, is not strict liability because he is the landowner, because he has rights in the water. Second, he argued none of this can be imputed to him. You cannot impute criminal behavior to a landowner. And third, he argued, I have heard no evidence, I have heard no statutes, I have heard no case law that suggests because he is a landowner, any act in violation of a court order can be imputed to him. The water court correctly denied the defense's motion, stating that the court finds Mr. Cease is the owner of the property. There is no question about that. After that, Mr. Cease's counsel did not object to that statement, that it wasn't at issue. Never challenged the court's statement that that was undisputed. For an issue to be preserved for appeal, a genuine issue must exist and must be raised for the trier of fact to resolve. The only issue properly before the court is whether the trial court could draw reasonable inference from Mr. Cease's undisputed ownership that Mr. Cease or his agents or employees committed the 17 violations. This reasonable inference was based not only on his ownership, but also on the nature of the very visible and obvious work that was observable on his property, and the court said it was reasonable to expect that he would be aware of that, especially given all his activities installing water structures on his own property. This court's previous ruling in the Vaughn case established the precedent that such an inference is reasonable if based on ownership of property and visible and obvious actions involving the property of which the owner is reasonably expected to be aware. In Vaughn, this court also held that it was reasonable for the water court in that case to similarly reject a baseless intruder theory due to the lack of any evidence to support such an unreasonable hypothesis. The water court properly concluded that because Mr. Cease owns the Cease Ranch and has previously in this case been involved with those water features and structures on his property, it was reasonable to infer that he was aware of such obvious and visible work being done on his property. The judge, in her order imposing punitive sanction, considered but dismissed the intruder theory. In doing so, the judge found it was highly unlikely that an unknown person would bring in heavy equipment to dig a ditch, to place and remove a pipeline, create and remove an impoundment on Mr. Cease's land without being paid to do so. The judge found it is highly unlikely that an unknown person would pay for a new pipeline or a slide gate, do the work necessary to install the pipeline to the stock tank, and to install the new slide gate on Mr. Cease's property without being reimbursed for the materials and without being paid for the installation work. And finally, the judge also found that although the changes to Sheep Creek are less obvious, it is also highly unlikely that an unknown person without the permission or the encouragement of the property owner would choose to come under Mr. Cease's property of all locations in the state of Colorado and make changes in Sheep Creek as it crosses his property. The water court rejected the unsupported intruder theory based on reason and common sense and rational consideration of all the evidence and the lack of evidence. The water court was left with the only reasonable inference based on Mr. Cease's undisputed ownership of the property. He was aware of the violations and approved of them, or he himself did them. As this court is aware, reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all the evidence or the lack of evidence in the case. It is a doubt which is not vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. We believe the court should affirm the water judge's conclusion based on substantial, credible, uncontroverted evidence in the record that the state proved Mr. Cease was guilty of contempt of court beyond a reasonable doubt, and for the purpose of remedial sanctions, the state proved Mr. Cease was guilty of contempt of court based on a preponderance of the evidence. Thank you, Your Honors.
Thank you. Appreciate the argument of both counsel. The case will stand submitted. And we're going to take a 15-minute recess. The bailiff will announce the recess.
Court is in recess until 10:42. in session.
Thank you. Please be seated. So we've got scheduled a one-hour argument in the case of Cowan v. People. Both counsel look like you're ready. You might have heard me reminding the other folks since we record these, if when you get up to the mic, you'd say your name and say who you're representing and try to talk into the mic. Oh, excuse me. We have this set for 40 minutes. Okay, and I'm sure you can figure out how to divide that equally amongst yourselves. Okay, go ahead, Ms. Chamberlain, why don't you proceed?
May it please the court, my name is Julia Chamberlain, and I represent the appellant, Mr. Cowan. In Nelson versus Colorado, the United States Supreme Court stated, Colorado may not presume a person, a judge guilty of no crime, nonetheless guilty enough for monetary exactions. But here the trial court did just that. It exacted $13,158 from Mr. Cowan under a lower burden of proof on his acquitted count. In doing so, the trial court violated a number of Mr. Cowan's constitutional rights, as well as the plain language of the restitution statute. In Nelson, the United States Supreme Court recognized that a defendant has fundamental rights to due process and the presumption of innocence under Colorado's restitution scheme. In order to read the restitution statute in a constitutional manner under Nelson, restitution awards must be limited to victims' losses caused by defendant's criminal conduct for which he was convicted. And numerous sections of the restitution statute support Mr. Cowan's position. For instance, after Nelson, the Colorado legislature enacted a restitution refund statute, which says that a defendant is eligible for a restitution refund if the charge on which the conviction was based is dismissed, or the person is acquitted of the charge after a new trial. It follows that if a person can receive a restitution refund from an acquitted charge and a retrial, that courts can't impose restitution on acquitted charge in the first instance. Further, the legislature in multiple places of the statute actually used the phrase criminal conduct. In the Crime Victim Compensation Board statute, it stated whenever the board pays a victim restitution, that payment is presumed to be the direct result of the defendant's criminal conduct. The legislature also defined victim in one instance as a person harmed by an offender's criminal conduct in the course of a scheme, conspiracy, and pattern of criminal activity. Although the Attorney General focuses on two sections of the statute where the legislature just uses the phrase conduct, each time the legislature does so, it qualifies this word with the term offender, and that means someone who has committed a crime. For instance, restitution is any pecuniary loss suffered by a victim or any other losses or injuries proximately caused by an offender's conduct. In the other instance, the Attorney General points out is one definition of a victim is any person aggrieved by the conduct of an offender. However, when reading the terms offender, which is very specific, it's not person or defendant, along with the term conduct, it's clear the legislature again meant criminal conduct here.
So let me just jump in. I suppose at some point somebody has to ask you a question, right?
Sure.
I'll start. You led with the constitutional argument, and then you're sort of moving to the statutory interpretation argument, and I wonder whether you shouldn't be flipping that, because it seems to me that, you know, under the doctrine of constitutional avoidance, maybe the better approach is to see whether we can resolve this simply at a statutory interpretation level, as you were just suggesting. I guess my question for you ultimately is, do we even need to get into Nelson?
Your Honor, no, you don't need to get into Nelson here. I think the plain language of the restitution statute does support Mr. Cowan's rule, which is that you can only impose restitution on a defendant's criminal conduct for which he was convicted. Again, even the purpose of the restitution statute supports Mr. Cowan's position. The purpose is for persons found guilty to be under a moral and legal obligation to make full restitution to those harmed by his misconduct. The purpose of restitution is also to compensate a victim, reintegrate an offender into society, to deter future criminality, and to rehabilitate an offender. And none of these punitive or salutary effects of the restitution statute can take place if courts can impose restitution on acquitted conduct.
So counsel, is it your position then that Pagan and Smith and Stotts were just wrongly decided?
Your Honor, to the extent that they plainly say that restitution can be imposed on acquitted conduct, yes, I think that is incorrect, especially in light of Nelson.
And if I could follow up on that.
Yes.
Relatedly, Borges, and I'm Cumurit, I'm sure I butchered that, say a criminal conviction establishing defendant's culpability is not required. Do we need to overrule those cases as well, or are they distinguishable?
I think Borges is distinguishable on the facts. There, the defendant pled guilty to theft at Target, and the counsel for the defendant admitted that the guilty plea was based on a series of thefts that the defendant perpetrated against Target, and the victim admitted her criminal conduct and the losses incurred by Target. So I think on the facts, it's distinguishable from here, where Mr. Cowan pled not guilty to the charged offense and the jury acquitted him of that. He never admitted his criminal conduct.
So in other words, Borges doesn't involve an acquittal at all? Is that I'm just trying to focus in on what the distinction is.
Yes, Borges doesn't involve an acquittal, and there you also have the defendant admitting their criminal conduct as well.
Could I ask a question for you, Mila? Do you
Yes.
think it makes any difference that this, do I understand right, this was a condition of probation?
Yes, Your Honor, this is a condition of probation. And here, if Mr. Cowan violates this condition of probation, the penalties that the trial court could impose on Mr. Cowan would be to, imprison him. It could be to extend his probation. So there's many other penalties that could result if Mr. Cowan ultimately violated his probation condition.
Does it make a difference that probation requires the acceptance by the defendant of the conditions?
Your Honor, I don't think it makes a difference here on the issue of whether courts can impose restitution on acquitted conduct. I think that's just a result of, one of the consequences of interpreting the restitution statute to allow courts to impose restitution on acquitted conduct.
And the defendant's not challenging the restitution on the first check?
No, Your Honor.
Okay, so
Mr.
it's only with respect to the $13,000 check?
No, Your Honor. Mr. Cowan is not challenging the restitution on count one.
Okay.
Yeah. And Mr. Cowan, excuse me.
Excuse me for interrupting you. Would the result be, or your argument be different if they had just charged him with one count and then and he was convicted and then they asked for restitution for the full amount?
Well, Your Honor, the rule that Mr. Cowan proposes is that courts can only impose restitution on a defendant's criminal conduct for which he was convicted. So to impose restitution, you'd have to look at the conviction and what that criminal conduct underlying that conviction was. So, for instance, Mr. Cowan here was only charged with fraud by check for $9,327. He wasn't charged with something else like theft, which would require an intent to permanently deprive the victim of the entire truck. So you have to look at the underlying conduct and, what the defendant was ultimately convicted of.
But if is the key part of your argument that he was acquitted and therefore it can't be added? Or is it, because it seems like from the facts, he owes the money. Now, maybe that's a civil remedy, but I mean, it sounds like the work was performed, right?
Well, I think that is something that was never really resolved down at the trial court, because based on the facts in this case, Mr. Cowan got his truck back and it wasn't even operable. And to the extent that the trial court found Mr. Cowan guilty enough on count two to impose $13,158, I think that was improper, because this court has repeatedly stated that restitution is not a substitute for a civil action for damages. This court has guided trial courts and told them not to hold an entire trial on the action of civil damages. So defendants don't even have due process rights on this restitution related to this acquitted conduct. They don't have the right to pleadings, discovery, to have a jury trial on this, or to present, a defense on how much Mr. Cowan actually owed for the remainder of this truck.
Counsel, I think this is maybe what Justice Boatwright is asking as well, but I'm curious, is the rule that you would ask us to establish that restitution can only be based on convicted conduct?
Yes.
Or, so uncharged conduct can't form the basis of a restitution order? That's what you're arguing?
Well, Your Honor, Mr. Cowan's case is obviously distinguishable from that, but as it relates to uncharged conduct, defendants also have a presumption of right and due process rights to that conduct. So to the extent that the conduct isn't in the actual conviction for, what the defendant either pled guilty to, no contest to, or was found guilty of beyond a reasonable doubt by the jury, I don't think that could be included in a restitution order.
And let me come back to probation for a minute.
Sure.
So, especially in response to your last answer, if a defendant was convicted of something, and with regard to that whole incident, it appeared that he had done more damage than the thing he was convicted of, ever charged with, you think it would not be permissible as a condition of probation for purposes of rehabilitating this person to say you have to make the victim whole, even with regard to parts you were not convicted of?
Your Honor, I don't think that would be in compliance with the rule in Nelson, which says defendants have a right to due process and presumption of innocence. So the extent that probation order would include restitution that the court found without, honoring the defendant's rights to due process and presumption of innocence, I think would be improper under Nelson.
But you wouldn't want to be saying, would you, that one cannot impose a condition of probation that the defendant was not actually convicted of committing?
Well, I think the issue of probation is different than determining the amount of restitution owed. Because under restitution, you have to go back to the statutes and see what they allow courts to impose on a defendant. And that's based on what the jury's verdict found and what the defendant was convicted of. So to the extent that courts can then exceed the limit of what the defendant was convicted of and impose excess money and tie it to probation, I think would be improper.
And do you think then, I'm presuming from what you're saying, that if the court were to feel, by failing to make the victim whole, the defendant should not be entitled to probation, it would be perfectly all right, as far as what you're saying, to only assess the restitution with regard to the crime of which he was convicted, but then send him to prison?
Well, Your Honor, I think the court would have to make that sentencing decision based on what the jury's verdict found. And to your point about making the victim whole, it's making the victim whole of criminal conduct. This court recently, in Meza versus People back in April of this year, said this court has long construed those statutory provisions broadly to obligate sentencing courts to order the payment and fix the amount of restitution as part of the judgment of conviction whenever the defendant's criminal conduct has caused pecuniary damages. So restitution is only concerned about criminal conduct for which the defendant was convicted of. Anything else should be, the victim has a remedy for any other losses that may be between that victim and the defendant, and that's to sue them in a civil court.
Following up on Justice Boatwright's question, I think the question was, in this case, the defendant owes the money. And I think you said something like the truck was not functioning properly or not working. And the jury found him guilty of the other check, though, right?
The jury found him guilty of that $9,327 check, yes.
So despite the whatever evidence or argument he may have made with respect to the truck not working properly. So I guess I'm trying to get at, does it make a difference in a case where you have two closely related counts, and the jury finds him guilty of one and then not guilty of the other?
I think it would be a closer call. I think in the restitution hearing, the prosecution would still have to prove that the restitution amount is related to the defendant's criminal conduct for which he was convicted. Here, I think we have two distinct, separate and distinct conduct underlying all the different checks that Mr. Cowan gave Elite Diesel that day, and which is recognized by the district attorney's charging decision in this case. There was the $15,000 check that Mr. Cowan gave for services to Elite Diesel, and this was a loan from Mr. Cowan's brother, Jared. Ryan. The district attorney decided not to charge him with anything related to that and never asked for restitution for that $15,000. In count one, that was the check for $9,327. Jury convicted him of this based on the facts that he had insufficient funds in his bank account. And then count two was charged separately, and the prosecution presumably did this because it's a different check, and there was different facts underlying it, and that was that he got a loan. He attempted to get a loan from Landmark Financial, and he was acquitted of that. So the district attorney here looked at all of the conduct independently relating to these three checks. So here, it's clear that Mr. Cowan's criminal conduct underlying count one, which was not fraud by check for $9,327, caused $9,327 of damages. So I want to, if there's no other questions, I'd like to reserve the remainder of my time.
You may.
Thank you.
Good morning, may it please the court. My name is Kathy Gillespie, and I'm here this morning representing the people of the state of Colorado. My number is 26109. I want to start by kind of outlining the defense's argument as to why we're here, and I think it's twofold. The first is they want you to find in the restitution statute that where the legislature used the word offender's conduct, they want you to find that it's the defendant's specific conduct of his criminal conviction. They want you to read that language into offender's conduct.
I have to interrupt you, Ms. Gillespie. I don't think that's a fair summary of their argument. 601 says persons found guilty of causing suffering and hardship. There is various references to offender's conduct. Counsel talked about other references to conviction. I think their argument is if you look at all of the restitution statute and the new refund statute, which talks about being acquitted of a charge, you get to the focus of the legislature was on a conviction. I'm sorry to interrupt, but I don't want to get too far down a wrong road where with all respect, I'm not sure that you were capturing the argument fairly.
And I would agree with you that they use the term conviction in other parts of the restitution statute, but my argument is that bolsters my argument and my position, which is in the restitution statute, they define what a conviction is in the definition statute, and then they define what restitution is, and they define what a victim is. So they make a very specific call as to when they use the term conviction in the restitution statute. And the reading that it would only apply to the conduct that the defendant is criminally convicted of committing would ignore a lot of the procedures that are set out in the restitution statute as well. The restitution statute doesn't tell the courts and the trial court to look to the facts of the case, the trial court proceedings, to decide the restitution. The due process for restitution that's included in the statute tells the trial court to hold a separate hearing, and that the DA is to provide information from a variety of sources, not just from the evidence admitted at trial, but to go to the victim impact statement and other means to determine not only what restitution is owed, but also to what victims.
So can I interrupt you and just ask, I know that 18.1.3703 does not apply specifically, the new restitution statute, the repayment, doesn't apply specifically to this situation, but how would it be rational to say that if you're acquitted under those particular circumstances of a crime you had been previously convicted of, you don't have to pay restitution or you get repayment of restitution, but in this situation where you're acquitted of conduct initially, you do have to pay restitution?
Because I think what the restitution statute tells you, and this is kind of in line with why I don't think Nelson is applicable in this case, is that there is a valid conviction. So I agree, and I think the law is clear, that in order to assess restitution, you have to have a valid conviction. And the situation in Nelson was, once all the valid convictions were gone, we essentially don't have jurisdiction over that person anymore to say that restitution, fines, and costs are.
Well, didn't it say the presumption of innocence is restored in Nelson once the conviction is gone?
Yes, but again.
And where does it say every conviction?
Because it said in Nelson, the language was, he's adjudged guilty of no crime, and the fines and costs were solely based on the convictions.
Sure,
that were-
and those are the facts of that case, of course.
Correct.
But they do talk about presumption of innocence. Does Mr. Cowan here have no presumption of innocence on the account for which he was acquitted? Because that would seem to be where your argument goes.
It's not that he doesn't have a presumption of innocence. I think what the restitution statute does is it looks at what he's convicted of. So he's convicted of writing the $9,000 check. The restitution statute then looks and says, look at the conduct as a whole and make full restitution for any pecuniary loss. And all losses are injuries that are proximately caused by the offender's conduct. So in this case, what the trial court based its restitution order on was the fact that the two checks were written to the same victim. They were written for the same truck at the same time. And the defendant admitted that he didn't have funds to cover either one of those checks at the time they were written. What I think is critical to this case is the trial court also finds that the defendant knew that without payment in full, Elite Diesel was not going to release his truck. So if he had not written the $9,000 check, knowing that there weren't funds to cover it, he never would have been given the truck to begin with. Then you go into the restitution hearing and you decide what is the proximate cause of all the losses associated with the conduct of the criminal episode.
So the acquitted, and if I can follow up,
Please.
Justice, the acquitted conduct then has no effect on the restitution. We basically then have a civil action in the middle of the criminal case. And you'd say preponderance, so it's a different standard, no problem.
Yes, and I think the trial court considers the acquittal. I think sitting as a trial judge, if you get to the restitution hearing, which is actually at the end of the criminal case, then I think the trial court can consider that the acquittal of the verdict. But if you don't consider the acquittal, then the preponderance of evidence standard doesn't make any sense. So you're saying that if you go to trial, restitution has to be proven beyond a reasonable doubt. If you don't go to trial, then the restitution hearing is by a preponderance of the evidence. So our legislature has made the decision, a policy decision, that to determine restitution, it is a preponderance of the evidence. So at the restitution hearing, I think the trial court can take into consideration whether or not there's an acquittal. But I think in this case, the trial judge made a discretionary call that based on the defendant's admissions that he knew he didn't have money to cover the checks, and the fact that Elite Diesel was still out the money, found that without the combination of the writing of checks, the truck never would have been returned.
May I jump in right there? Because I think I see a distinction between the $9,000 check and the $13,000 check. The defense, as I understand it, with respect to the $13,000 check, was that there was no intent to defraud because the defendant thought he actually had a loan in place. And it seems that, at least based on the jury questions submitted and the acquittal that followed, that the jury actually believed that. In other words, there was no intent to defraud with respect to the $13,000 amount. And I guess what troubles me at the restitution hearing is that it seemed the trial court, despite that acquittal, concluded that, I think by a preponderance or beyond, you did intend to defraud with respect to the 13, and therefore I'm going to lump that into restitution. I think that is your opponent's argument, so help me understand why that's okay.
Well, I think the first step in that is the restitution. To determine the amount of restitution, you're not looking at necessarily the elements of the crime. So restitution is a wholly separate determination. It is all the pecuniary losses that are proximately caused by the defendant's conduct. And so I agree with you that may have been what the jury decided, but our legislature has said for restitution purposes in the statute that it is a preponderance finding, not a beyond a reasonable doubt. And so while the DA may not have been able to prove necessarily that intent beyond a reasonable doubt, when you get to the restitution hearing, it is a different burden of proof. And what you're looking to prove is different than what you're proving in the jury trial, which are the elements of the offenses charged.
So let me throw out perhaps like a different hypothetical, because our two checks are same day, same account, same person, all of that. Let's take a different situation. Let's say a sex assault and a theft. Ex-boyfriend comes in, sexually assaults the ex-girlfriend. Some time passes, maybe an hour or two later, on the way out the door, he swipes some jewelry. So we have a sex assault charge and a theft charge. Let's say the jury acquits him of the theft charge. Can he be on the hook for restitution for the $1,000 ring that he was accused yet acquitted of taking?
I think if the DA can prove by a preponderance of the evidence that the loss of the ring was a proximate cause of the sex assault, or from the conduct underlying the sex assault, then yes. And I think if this court wants to reach a different decision, it's going to have to overrule 5 or 6 of those Court of Appeals cases, and also make a distinction on this court's case in Dubois, which said you're not limited by, restitution is not only limited to persons injured by the conduct directly underlying the criminal conviction. Nelson was part of an exoneration act. It wasn't part of the restitution statute. I understand restitution was ordered in the case, but Nelson was looking at the due process of the procedures in the Exoneration Act. Since Nelson came down, many federal courts have tried to overturn Watts on the basis of Nelson, and that's not successful. We can sentence defendants for uncharged and acquitted conduct as part of a sentencing discretionary judgment call. We can introduce acquitted conduct or uncharged conduct as evidence of guilt in a criminal trial. So I do think that as far as the restitution purposes go, I think those are the arguments that the defense needs to make in the restitution hearing to the trial court itself. But what this case law and this court has said is that it is the underlying conduct. It is a different burden of proof, so the collateral estoppel is not implicated.
Can I come back to 18-1.3703 to follow up on Justice Hart's question? I understood your argument that as long as you're convicted of something, we can look at everything. Do you make anything out of the fact that 703 talks about the charge? I mean, it doesn't talk about the whole judgment. It doesn't talk about one conviction remaining. It says you can get a refund if the person is acquitted of the charge after a new trial. One could argue that they're talking about one count as a charge. Do you make anything out of that? And I recognize the statute doesn't directly apply, as Justice Hart said.
Correct. Other than those obvious responses, I don't think it does. I think the legislature was clear in its intent when it introduced that bill that it was in response to Nelson. And I think Nelson is very clear that it's talking about a situation where there is no conviction remaining on the defendant.
But what language do you see in 703 that says that? My concern is the same as Justice Hart's. It seems a little inconsistent.
So there's a variety of language. First of all, I think the obvious is that it's the reimbursement and things that have actually been paid. But I think down below it says they're monetary amounts resulting from a criminal conviction in the district court or the county court if the amount paid relates solely to that conviction. And our argument here is that the amount doesn't relate solely to the acquitted conduct. The amount, the sole conviction that remains on this defendant's, that the restitution in this case is tied to, is the one he remains convicted of. So if the court had said that he was, if the court in its findings didn't tie the $13,000 check to the conduct that was underlying the conviction for which the defendant suffered, then I think it might be a different scenario as far as finding of proximate cause by preponderance of the evidence by the trial court. But I think the fact that this was in response to Nelson and the limits of that ruling, I think taking that and expounding it upon restitution, especially in light of Alito's concurrence and some of the distinctions of restitution that weren't fleshed out in this case, and the fact that a restitution hearing is part of the criminal process as opposed to, so the difference between whether it would look under Medina or the Matthews factors, I think that issue itself isn't addressed by Nelson. And I think trying to squeeze this case into the Nelson holding and what the legislature did in response to Nelson, which was fix the process that's required when someone is exonerated or all of their convictions disappear, I think is a mistake. And I think in order to do that, this court is going to have to ignore quite a bit of language in the restitution statute and overturn what has been the Colorado case law for quite some time in the 5 or 6 Court of Appeals cases that I cited in my brief.
Ms. Gillespie, would you concede that Nelson is at least substantially implicated by this problem?
No, I would not.
Okay. You probably anticipated my next question, which is, to the extent it is, right, doesn't the doctrine of constitutional avoidance suggest that any ambiguity in the restitution statute should be construed to eliminate the constitutional problem? So I sort of, apropos of the question that I asked opposing counsel earlier, I wonder, even though this isn't really a doctrine that's discussed in the briefing, whether that has some application here. But I guess, you cut it off by just saying it's not a substantial question. Nelson doesn't apply.
That's the first line. The second line would be, I think the language in the restitution statute broadens it enough. I think the fact that they define conviction and then choose in different parts to use misconduct and offender's conduct as opposed to conviction. And one of the places that I wanted to point out was there's a subsection within 602 where the legislature they assess restitution for first, second, or third degree assault. And they say, it says specific restitutions for persons convicted of various assaults. And then when they go down and they're talking about, it sounds like a co-defendant situation, that if a victim is somebody who's responsible for the same crime or crime arising out of the same criminal episode or plan, I think all of those places in the restitution statute, the legislature chose not to use the word conviction. And I think that goes back to what this court recognized in Dubois, which was in 2000, instead of just victims being the persons named in the complaint, everything was broadened to have a more liberal policy for the restitution for the reasons the legislature gave.
Go ahead, please. No, I was going to move in a different direction. You
So
go.
am I. So-
Yeah, go ahead.
Okay. And I know your time is limited, but sitting here kind of thinking about how this would play out, let's say Mr. Cohen at trial's defense was, he didn't fix my truck correctly. Would that even be relevant?
Well, according to this court's decision in Johnson, no, because this court in Johnson said comparative negligence, things of that nature. If he is convicted of the crime, then my argument would remain the same, so long as he was convicted of one check that caused Elite Diesel to release the truck.
Right, but what I'm sensing is we could have an inequitable result if he's never able to present evidence that the truck wasn't repaired properly. Then we're going to turn the restitution hearing into with discovery and all of that. It seems like if he's convicted, there's a presumption that the amount is correct. If he's acquitted, how do we determine what the correct amount of restitution is?
Abuse of discretion, and there has to be evidence in the record to support the trial court's decision by a preponderance of the evidence. I mean, the courts have been doing this for at least since 2000 when it was broadened. So courts are daily doing these kinds of judgment calls involving restitution at the behest of the Court of Appeals opinions and this court's opinion in Dubois. So I think that you leave that up to the trial court, and if the DA can make that link and the trial court can make findings that it's the proximate cause of the underlying conduct, then I think the restitution allows for that award.
If I can follow up with Justice Boatwright's question, do you agree that restitution is not a substitute for a civil remedy?
Yes.
So isn't Justice Boatwright's example exactly why this issue should go to civil court and let Mr. Cowan argue the truck wasn't fixed, that's why I didn't pay? I mean, isn't this the prototypical example of why this shouldn't be a restitution issue, it's a civil action?
I think what the courts have found, I think it's the Court of Appeals have found for the most part, a little bit in Johnson, is that the purpose of the restitution statute is to make the victims whole, and asking victims to go into civil court and wait for that restitution, if they can show the standard that the legislature requires in the criminal case, doesn't force them to go over into the civil remedy. And if the defendant wants to challenge, or he presents the evidence at the trial court level.
So then restitution is a substitute for the civil remedy in this context. I'm not sure what the distinction is.
I think the distinction goes back to what the legislature has said the procedure should be in the statute, which is, you've been convicted of a crime, and now the DA is going to put in information from a variety of sources as to what the amount of restitution is, and the trial court's going to make a judgment call by a preponderance and award the restitution.
And so, I'm sorry to take so much of your time. So you would say the defendant then gets to put on a defense that the truck didn't work at the restitution hearing?
I think that depends on the trial court itself. I think in this case, there was some evidence presented at trial, which the court found. The evidence presented at trial was that there were pretty minor fixes to the truck and didn't justify Elite Diesel not being paid anything for the repairs. So I think the court did make those findings from the evidence that was presented at trial.
Follow-up question. And I know we're past our time. If we were to rule that restitution cannot be ordered for conduct for which the defendant's been acquitted, would we have to overrule Dubois?
Yes, I think so.
Thank you.
Kimberly?
So the Attorney General asked this court to apply the preponderance of the evidence standard to determine a defendant's guilt on acquitted conduct in a restitution hearing. And Nelson clearly stated that courts cannot presume a person guilty enough for restitution. Restitution hearings are to determine whether a defendant's criminal conduct caused a victim's damages, and if so, how much. There's nothing in the statute that allows courts to start relitigating a defendant's guilt when the jury found to the contrary, that they were acquitted of the count.
Ms. Chamberlain, I don't want you to run out of time. Would you answer the question Justice Boatwright just asked Ms. Gillespie? Do you think we have to overrule Dubois if you win?
I don't believe this court needs to overrule Dubois to find that courts can't impose restitution on acquitted conduct. Dubois was a very narrow case where the court wasn't even determining the preponderance of the evidence for proximate cause purposes. All it was determining was whether a officer who was responding to a vehicular eluding crime was a victim for purposes of that statute. And here, none of the facts involve the vehicular eluding statute or defining victim.
And there was no acquittal in that case, right?
There was no acquittal in that case, so it's very distinguishable, and it was a very narrow holding as well. The Attorney General focuses, again, on those two places where the legislature only used the term conduct. However, in other sections of the restitution statute, for instance, in the Crime Victim Compensation Board statute, the legislature actually uses the term, if as a result of the defendant's conduct, then the Victim Compensation Board pays the victim restitution. That payment is presumed to be the direct result of the defendant's criminal conduct. So here the legislature is actually using defendant's conduct and criminal conduct interchangeably. So I think when looking at the statute as a whole and looking at the purposes of the restitution statute and the fact that a conviction of a felony is what triggers restitution in the first place, I think restitution awards need to be limited to a defendant's criminal conduct for which he was convicted.
Let me ask you one more follow-up, because I'd like you to address something Ms. Gillespie said. How do you square your argument with the fact that in sentencing, we can consider, or trial courts can consider uncharged conduct?
Your Honor, I think that to the extent that the uncharged conduct is not included in the conviction, and it's not the basis of the criminal conduct for which the jury found him guilty, I think a defendant needs to be presumed innocent of uncharged conduct. And I think that would also be a civil matter where the victim could then sue the defendant in civil court.
What about a situation where, like a plea agreement, as part of the plea agreement, we agree to drop certain charges and you plead to a lesser offense, et cetera, et cetera. How does that play out there?
That's the situation in Borges. I think so long as the restitution statute has a factual basis supporting the restitution amount, that courts can still impose restitution on uncharged or dismissed conduct in that context.
So you were drawing a distinction between the uncharged conduct and acquitted conduct.
I think the restitution statute has to have the factual basis for that restitution amount. So if, for instance, the defendant pleads guilty to one theft and all the other thefts are dismissed, but the terms of the restitution, of the plea agreement say, I agree to make a payment for all of these, dismissed counts, all these dismissed thefts, I think that's still proper.
Okay, thank you.
But that wouldn't be true as a condition of probation, I take it.
Well, not at a jury trial where a defendant, pleads not guilty and is acquitted of that conduct. I also just want to focus on Nelson for a second. The United States Supreme Court was focusing on Colorado's restitution scheme and found defendants have fundamental rights to due process and a presumption of innocence. Even Justice Thomas, who is the sole dissenting judge in that case, reasoned that no one disputes if petitioner had never been convicted, Colorado could not have required him to pay the money at issue. Here, because the jury acquitted Mr. Cowan of count 2, he must be presumed innocent of this charge, and Colorado should not have required him to pay the money at issue. Thank you.
Thank you. The court appreciates the argument of both counsel. Case will stand submitted, and the court will be in recess until 1:30.